Solomon Seay Jr. stands beside Thurgood Marshall, Constance Baker Motley, Jack Greenberg, Spotswood Robinson, Arthur Conoy, and most importantly beside Arthur Shores, Z. Alexander Luby, Clifford Durr, and Fred Gray, his colleagues, as one of America's quintessential civil rights lawyers. His book, Jim Crow and Me, written with Dolores Boyd, is, as the great John Hope Franklin says, a book written about a lawyer who had a special prism through which to view the momentous events of the civil rights movement, and who fought Jim Crow wherever he found it. Mr. Seay, words cannot describe the privilege of sharing this conversation with you in Montgomery, Alabama on August 2nd, 2010. I must begin with one of the last passages from your book, because it defines why we have imagined and established the Stetson University Oral History Project. The passage in your book is an African proverb, which reads, "Until the lions have their historians, tales of the hunt shall always glorify the hunter." You illustrate this proverb in your book by recalling early your conversations with Judge Frank Johnson and Virginia Durr, both of whom are well known for their roles in the movement, and both of whom you respected and admired, on the subject of assumptions made about race. And I agree with your observations that in the 1960s, many whites wrongly assumed that a black person who was an active advocate for racial equality probably hated all white people, but that it was true that there was a necessary measure of distrust of whites for good reason. I find that a favorite passage from your book, and I think it says something very important to begin our conversation.
There are several things that come to mind as you read that. One was the conversation, of course, that I had with Mrs. Durr. There was some conversation as to whether I was coming. Miss Durr expressed the notion that I probably would not because I did not like white folks. When I learned of that, it really disturbed me. And I tried to turn it off in a rather joking fashion because it was Saul Seay to try to find some humor in every even tragic circumstance. And so when Mrs. Durr said, I didn't think you were coming because you don't like white folks, my response was that, Ms. Durr, that's just not correct. I do not dislike white folks. I don't dislike any person. I said, but now, if I had done to y'all since 1619 what y'all have done to me, would you trust me? I think not. And, you know, for the reason I don't trust y'all, but I don't dislike y'all. And I was brought up in an environment not of dislike, but of always being very careful and very correct. And you know, when I first came to Montgomery to practice law in Alabama, there were two black lawyers here, Fred Gray, who perhaps was the best known civil rights lawyer in the country, and Charlie Langford. But both of them had only been here a year or so. I started solo practice. And of course, there were a lot of things that I just didn't know about the practice in Alabama. And Fred and Charles didn't know much more about Alabama practice than I at the time. And whenever I ran into a situation that was just foreign to me, I would stop and think about who in this area is an expert in this field. And I'd give them a call. Solomon Seay, hey, my man, look, got a problem with such and such a thing, you know? Wonder if you could help me out. There was never a single time that a white lawyer whom I called turned me down. Not one time. But at the end of the conversations, there was always the caveat. But now, nobody needs to know that I helped you with this, you know. But I was never turned down.
When it became well understood that you were going to fight Jim Crow and that you were going to become a local lawyer who would confront the fundamental issues of this region, did that change your relationship with the bar, or did it have any special influence on your life?
Not really. But one thing that it did was it made me be always careful to adhere to a standard of excellence, because I was under scrutiny all the time. Now, what do I mean by that? I could draft a complaint to be filed in the circuit court, and I would take it to the court and hand it to the clerk. And before filing the document, quite frequently the clerk would sit there and thumble through it or read parts of it or just look at it. And sometimes have a comment like, you know, see, this is very neat. Who is your secretary? You know, as if my stuff ain't supposed to be, you know, that neat and that correct. And so I was always careful to make sure that I persisted in pursuing a standard of excellence in everything that I did.
Your 1957 case on behalf of Mark Gilmore against the city of Montgomery, arising from Mr. Gilmore's arrest for trespassing, successfully challenged one of the classic examples of the denial of social equality, the practice of cities to segregate public parks and playgrounds on the basis of race. When you pursued that case, in spite of efforts to persuade you to withdraw it, the city closed Oak Park and its other parks and swimming pools to prevent their integration. Judge Johnson ruled in your favor, holding that while the city could not be ordered to operate public parks, if it did reopen them as public parks, the policy and practice of restricting the use of those parks to whites only would violate the Equal Protection Clause of the 14th Amendment. Following Judge Johnson's ruling, the city and countless other cities throughout the South kept their parks closed altogether for years. And it was not until 1970, I believe, that Judge Johnson's basic ruling in your favor was reaffirmed by the United States Supreme Court in the Palmer case, which arose in Jackson, Mississippi. As you look back on a city's willingness to keep its public parks closed for 10 or more years, rather than allow black citizens to use them jointly with white citizens, it seems that that line of cases reveals the true significance of Jim Crow as it was invented in Plessy, that it emphasized the importance to whites of maintaining social inequality. We see this in all of the cases that come from the sit-in movement and the freedom rides. How did you see the incredible nature of that kind of obdurate resistance to social equality, and how did it prepare you for your later cases?
Gilmore was one of the earliest cases. But before Gilmore, I had done a number of criminal civil rights cases. And I came from Howard particularly equipped to do that. I represented a number of blacks on death row in Alabama on a very simple issue. And I was very successful at that. And those cases, I believe, prepared me to get over into the area later of civil rights that I got into. It was good for me to start in those cases because it acquainted me right away with the persistent opposition that I was going to have if I stayed in the area of civil rights. And it taught me a lot about what I would have to look forward to and some of the things that I would have to be wary of in later civil rights cases.
Black lawyers of your age understand that the legal question of racial inequality is inherently a question of the indignity and immorality of racial inequality because you experienced it personally at the Elite Cafe and in your case in your own state's bar association. Is there a way of helping students who may never have experienced a disregard for their dignity, who may never have had the personal experience of racial segregation or living in its culture, be they white or black, understand the need for empathy and the need to resist complacency when you see injustice?
Well, it's exactly what you're doing, and that's, as I understand it, in a large measure, history. Getting something to our young folks, especially the young lawyers, so that they will have some notion, at least of where the black lawyer has come from. And a better understanding of where he has to go, and perhaps a greater knowledge of how to get there. You know, I participated in a seminar back in the spring, I think it was. And there were a number of deans from several black law schools. I think they were mostly historically black law schools. And I was shocked and dismayed to hear a couple of them talk about our post-race society. And of course, you know, the bottom line was I finally had to interject Solomon Seay into that, and I wasn't really comfortable doing it because Solomon Seay can't pick arguments with people as prestigious as deans of law schools. But you know, I said to them that I was really taken by surprise after the inauguration of Obama, whether that was on the 20th or the 21st, and that's an open question. But after the ceremony, press from everywhere is sticking cameras in everybody's face and asking them what they, you know. And I was shocked and dismayed at the number of folks, black and white, who said that the inauguration of Obama was the culmination of the dream of Martin Luther King. And if we have the audacity to believe that, then we got problems. We got problems. Because that does not signify a post-race society. And even though those very prestigious lawyers that you named earlier had gotten together and pretty much buried Jim Crow, bigotry at that time arose like the phoenix from the ashes, and yet more sinister, you know, and more subtle, and more difficult, really, to attack. You know, you're talking about strategy. It didn't require a whole lot of strategy back at that time when we were fighting Jim Crow. The opposition was proud to say, yes, you know, we believe in separation of the races, you know. We've not reached a post-race society, and custom and habit it's difficult to overcome. And I realize that. And oftentimes, you know, I do take that into consideration and that determines sometimes how delicately I approach some of the civil rights matters that I have to handle.
What was your relationship as civil rights lawyers in a community that was so embedded in the civil rights struggle? Could you just reminisce a bit about you and Mr. Shores and Clifford Durr and just how often you saw each other, generally how much you all worked on some common thread of advocacy? There must have been an amazing bond among this group of lawyers.
Well, let's talk first about Cliff there. Alabama had a law which required a person to have the recommendation of 5 lawyers who have been practicing law for 5 years or more as a precondition to sitting for the bar. In '57, we did not have 5 black lawyers with 5 years experience or more. Clifford Durr signed a character affidavit for me. And what happened my senior year in law school? I was introduced to Cliff. And so on the basis of that, and the fact that he knew my dad better than me, he was able to sign the character affidavit, which permitted me to take him out. Cliff introduced me to the federal court. And when I was sworn in, on the day that I was sworn in, Cliff was the person who made the recommendation that got me admitted to the federal bar. And the little fee at the time was $10. And I wasn't aware that I had to have that $10 that day. So I ended up borrowing $10 from Cliff in order to pay the fee for becoming a member of the federal bar. Now, that's just the kind of guy that Cliff was.
I'd like to close our conversation by returning to the second story you tell in your book to illustrate the African proverb I mentioned earlier. You recall the story of Willie Dunnigan's murder in 1957, presumably by members of the Ku Klux Klan, and the ironic experience of defending the many black men who had been arrested by the local sheriff after the murder. You then recall that 50 years later, in 2008, you learned from Willie Dunnigan's death certificate and from his daughters that he and their mother had in fact been shot by sheriff's deputies, and that this revelation deepened your understanding of the civil rights struggle and why that struggle continues. It is painful but necessary for all law students to know that throughout the 2 most significant decades of the civil rights movement, state and local law enforcement and the legal systems of much of the South were directly and deliberately a part of the violence of Southern resistance and a part of judicial action which deliberately and with racial bias denied black citizens justice that would have been given any white person. The atrocities of this period have a legacy, and to forget them or to teach constitutional law or criminal law or, for that matter, any law in a way that marginalizes the history of race and the law is to perpetuate the law's failure to make social justice its highest priority. You end your book by saying that your soul still stirs to be on the battlefield. And John Lewis, in his foreword to Fred Gray's book, says this: "We worked closely with our lawyers to challenge unjust laws and practices. We depended on their wisdom and their wise counsel. They firmly defended the Constitution and the Bill of Rights during the Civil Rights Movement. Without them, the world would be a different place. We are, Mr. Seay, in a better place because of you and everyone like you who, as an advocate, dedicated their careers to civil rights. But as the last words in your book imply, the struggle continues. Mr. Seay, there's no way to tell you how privileged we feel to have been with you.
There's no way that I can adequately express how proud I am that you would select me to do this.
Thank you, sir.